Good morning. Good morning. Thank you for joining. Thank you for joining this webinar. I'm Angus Menzies. I'm one of the founders and partners here at Horsfield Menzies. Yeah, we're delighted to be able to speak to you today about the latest strike busting proposals from the government. So there will be a few more people joining us as we go through, but we're past the time of starting now. So I'm going to crack on, and I would say also we are recording this, so we'll endeavour to get these slides out to people after the session, and also the recording will be available on our social media as well. So thank you to those who've joined so far. If you have any questions going through, please feel free to pop them in the Q&A, and we'll keep a check on those, and there'll be an opportunity at the end to go through those questions. Feel free to be on screen or off screen. You're all currently muted at the moment. If at the end you want to ask a question orally, then we can obviously unmute at that point. But otherwise, as I said, feel free to put it in the Q&A. Okay, let's get cracking. So, title of the employment webinar today is Undemocratic, Unworkable, and Almost Certainly Illegal. When I first did the slide, there was an unfortunate juxtaposition between that title and my name, so I've moved them to my name to the bottom of the slide there, so it doesn't look like I'm describing myself. It's obviously a quote from the Trade Union Congress General Secretary Paul Novak, and we'll come on to why it is that he feels so strongly about it. What I'm going to do, though, for the purposes of this webinar, is I'm going to assume basic knowledge around industrial relations law. This isn't really the time to go into any great detail about industrial relations law, but we'll assume that people understand that where a union has balloted correctly and has conducted the notification and the ballots in accordance with the statute, then they're not going to be liable to injunctions, and they're not going to be liable in tort for losses arising from their inducement of their members to breach their employment contracts. So we'll take that as read. And if we also take as read the fact that if an employer dismisses an employee for taking part in industrial action such as strike, then where that's the reason, it's likely that the tribunal is going to find that it's an automatically unfair dismissal. And obviously the significance of automatically unfair dismissal as opposed to a dismissal that's just unfair on general principles is that for automatically unfair dismissal, you don't need 2 years service, and also the compensation available to individuals found unfairly dismissed in that way is unlimited. So without further ado, we'll crack on. Undemocratic, unworkable, and almost certainly illegal, so says the TUC. So it's obviously fairly strong language, and we're going to review these proposals that the government's brought forward this month. I want to talk about the strikes, which is the issue that the government's seeking to address, and why they're addressing them in such a, I suppose, robust manner. I want to talk about the government's proposed solution, which is obviously this bill and their hope that it becomes law, and how the bill will work in practice if it does indeed become law. And I want to then talk about why the trade unions are up in arms. You'll see and probably understand that there's very strong feelings on both sides here. And then finally, we'll talk about what it means for your organisation and just my own thoughts really about, where I think this might go. So let's crack on. So we've just had what some have referred to, and we're still experiencing the winter of discontent 2.0. More than 1.6 million days, working days lost to strike action between June and November last year alone, and that was before taking into account December. And I remember driving somewhere, presumably because the planes and trains were on strike, and I was listening to the radio, and I think it was Nicky Campbell said that he'd got a note in front of him which said that there wasn't going to be a day without strikes between that day and I think middle of January, apart from maybe New Year's Day and the following day. And I subsequently looked into this, and sure enough, there were calendars where there were sort of colourful circles to mark whether there was a strike in transport, or whether there was a strike in health, or whether there was a strike in education, or whether there was a strike in logistics or government. civil service, and certainly looking at the 2 calendar months, January and December last year together, each day had numerous colourful dots in it. Looked like, if I'm honest, looked like a couple of Connect 4 tablets in effect, because it was just so colourful, and all these days completely full of symbols to show that there was strike action happening. So that was December and January. Obviously, we're still in January. And so if it was 1.6 million days between June and November, and I know there was potential for a further at least 1 million days, working days lost to strike action in December, and we've had January as well. I think there were still strikes this week, certainly in London on Chiltern Railway. So it's still happening. So we're probably at something like 2.5 million working days lost since June to last year to now, which seems like an awful lot, and it is. But if we compare that to, if you like, the bad old days of the late 70s or early 70s, late 70s and early 80s, we can see that actually we're nowhere near the kind of the winter of discontent of 78, 79, for example. 29.5 million working days lost in 1979, 27.1 million days lost in 1984, and 23.9 million days lost in 1972. So yeah, we're miles away from that. However, I wonder if we regard the impact of current strikes as greater because we're just less used to dealing with strikes. Then, we had a long period where there wasn't really that much strike action going on, and all of a sudden in the last year, 18 months or so, it feels like we've got an awful lot more. So I think on one side there's that sense that potentially we have a problem with strikes, a real problem with strikes, because they're happening all the time, and on the other side I think there's people who say, well, I can work from home, strike doesn't really impact me, it's a bit of a pain, but I just work from home if I know there's going to be no trains. That's all very well if you can work from home, of course, but many people can't. Many people, work in education, they work in health, and they need to be at hospital, or at school, or at the factory, or on site. So it's very easy for those of us who can't work from home to say, well, strikes, they don't really affect us. But for many people, they do. Both those who are working in those sectors, but also those who need them. So if you're in desperate need of an ambulance, then the fact that you can work from home is neither here nor there. You need an ambulance to get to hospital. So there's no doubt, I think, that although far fewer people are members of unions, and therefore that has an impact on why we have we have very low levels compared to the 70s and 80s in terms of working days lost. But strike action can still be fairly disruptive. I think there's also an argument that because strikes may be individually less disruptive than they were in the past, one of the union's tools is to actually have more of them, and that's something which we'll touch on later as well. Okay. So what's the government's solution? They obviously seen this as a real issue. Well, it's the Strikes Minimum Service Levels Bill, and it wasn't exactly a surprise when this was published earlier this month. So back in 2019, ahead of the general election, the government committed in their manifesto to introduce minimum service levels in relation to transport. And sure enough, that's what they've done, but they've gone an awful lot further. There was also the government's growth plan, published, I think it was Kwasi Kwarteng at the time. I'm trying to work out how many chancellors we've had since September 2022. I think it is just the one. Where the government said in their growth plan, the government will introduce legislation that will ensure minimum service levels can be put in place for transport services, limiting the impact that industrial action can have on the public's ability to make the journeys that are essential for day-to-day life. Now, you'll see, both in relation to the election manifesto and in relation to the growth plan, it's all about transport. And sure enough, 20th of October last year, they introduced the Transport Strikes Minimum Service Levels Bill. Now, that would have required employers and unions to seek to agree minimum service levels, and if they couldn't agree minimum service levels within their sector, their organisation, then they were entitled to seek an adjudication from the Central Arbitration Committee. And if that still wasn't satisfactory to the parties, then a final decision on what constitutes a minimum service level would have rested with the Secretary of State for Transport in that case. So then fast forward to where we are now. We'll fast forward to to the latest bill. And actually, you'll see that it's very similar to the previous bill, save that it's not limited to transport. And this comes after they'd published the Transport Minimum Service Levels Bill, and then there were further strikes in various other sectors. And as a result, back in December 2022, Rishi Sunak, who was Prime Minister by then, set up a specific strike response unit to deal with strikes across numerous sectors, not just transport. Now, on 5th of January this year, we then had this press release from BEIS, trailing the extension of minimum service levels legislation to sectors beyond transport. Now, ostensibly, that press release was supposedly inviting union leaders to get around the table and discuss how we could thrash this whole issue of strikes out between us. But actually, reading down through the press release, it was really more this kind of trailing of the fact that minimum service levels were going to be introduced beyond the original sector of transport that had been promised in the manifesto. So that was on the 5th of January, and then sure enough, on the 10th of January, we had the publication of the Strikes Minimum Service Levels Bill, and that had its first reading on the 10th of January and its second reading on the 16th of January. So what does it do and what's it for? The government's press release announcing the Minimum Service Levels Bill, the Strikes Minimum Service Levels Bill, said it was to ensure that striking workers don't put the public's lives at risk and prevent people getting to work, accessing healthcare, and safely going about their daily lives. And what they said was, in the first instance, they were going to consult. There would be consultation in relation to minimum service levels in fire and rescue, ambulance, and rail sectors. And they said that further down the line, although they hope not to, because they hope that the industries and the unions will sort things out themselves, they will, if that doesn't happen, also introduce regulations in relation to minimum service levels in education, in other transport areas, in other health areas, nuclear decommissioning, and border security. And what the bill will do if it becomes law is to allow the Secretary of State, now it's the Business Secretary now, rather than just the Transport Secretary, although the Business Secretary now is the person who was the Transport Secretary. So in either case, it would have been Grant Shapps, and he's going to be given the ability to make minimum service regulations, setting out the minimum service levels for strikes in relevant services. Now, the relevant services are still to be defined, but they must be within those sectors that I've mentioned. So we're talking fire, ambulance, rail, education, transport, health, nuclear decommissioning, and border security. Now, there has been quite a lot of talk about safety and how this is necessary for safety, and I think we can all agree probably that if you don't have minimum service levels inside a nuclear reactor, for example, that needs decommissioning, then things could go horribly wrong. So I think many of us could get behind having minimum service levels in things like nuclear decommissioning. I think we can also agree that massive queues at Heathrow and Manchester and Glasgow and all sorts of other points of entry in the aviation sector is not what we want, and therefore it's good to have minimum service levels in border security as well. I think it's a bit harder to argue that in relation to things like education. Is it really a matter of health and safety if the teachers are going on strike? And I suppose what people say is, well, yes, potentially in relation to vulnerable children it is, but it just seems a little bit more nuanced there. But that's one of the areas for discussion and consultation. It should be said that consultation in relation to minimum service levels is with whoever the Secretary of State considers appropriate. So whilst you can certainly expect him to consult with employers in those sectors, he may or may not decide that he wants to, or she, if it's not Grant Shapps in future, they may or may not decide that they wanted to consult with the unions as well. I must admit, there's a lot of talk about consultation in relation to this whole bill, and one of my thoughts around that is if consultation between the parties was something that was likely to work, then we wouldn't be in this situation in the first place in having the strike. But we'll see how that gets picked up. So how the new law works. when a strike is called, and we're assuming it's being called legitimately, and that the appropriate notice has been given by the union to the employer, and the appropriate balloting has taken place. So when a strike is called in a relevant service, the employer may give a work notice to the union at least 7 days prior to the planned strike, or later if that's agreed with the union. And that work notice must identify workers who must work and the duties that they must perform in order to comply with minimum service levels. The work notice can't identify any more persons than are reasonably necessary for the purpose of providing the minimum service levels. And again, I think, this whole reasonably necessary point is something which lawyers and HR practitioners and employers have argued about for generations, and they're clearly going to have to keep on arguing about what's reasonably necessary in relation to minimum service levels. However, again, although the employer is supposed to take into account what the unions say about what constitutes minimum requirements in terms of staff and the jobs that they're supposed to do, ultimately that decision is for the employer. They can vary the work notice, again, as they have to do that no later than 4 days before the strike action, or later if they agree with the union, and only after consultation with the union. So they can change the numbers that were in the original strike notice, and they can change the duties if having to consult with the union, they've changed their mind over what's required. But ultimately that decision over what's required will be one which the employers can take. As I've said, the employers have got to consult the union on required employee numbers before issuing the work notice. Now, if there is then a duty on the union to take reasonable steps to ensure that its members comply with the notice. If they fail to take reasonable steps to ensure that their members comply with the notice, and if that results in people identified in the works notice remaining on strike or going on strike when they've been identified as people who must work, then that will likely result in the loss of union immunity from tort liability, and that could potentially enable the employer to have the strike declared unlawful and succeed with an injunction. It could also lead to union liability for damages resulting from those employees breaching their contracts and failing to work. So again, if the employer loses money because it can't operate even a basic service, because those identified in work notices have gone on strike anyway, then they can potentially sue the union for inducement to breach, and the union won't have that immunity from liability that they would have had prior to this bill becoming law. The other point which is significant here is that if those employees do go on strike, having been identified in a work notice, then they will no longer have that protection against protection from automatically unfair dismissal. So effectively, the employer could dismiss those employees and for failing to work when identified in a work notice, but that dismissal will no longer be automatically unfair. It may still be unfair on general principles if due process isn't followed and if there isn't a fair reason, but it won't be automatically unfair. And I suppose that means that employees with less than 2 years service will certainly be at greater risk there. Query whether it actually helps an employer to dismiss those who go on strike who've been identified in a work notice, because dismissing them doesn't actually solve the problem of not being able to run a basic service or to adhere to minimum service levels. It might make the matter worse, it might make it more difficult. But that's something that employers are going to have to grapple with. So that's how the bill is intended to work, how employers will effectively benefit, and how workers will be put at something of a disadvantage, let's say. And as a result of that, the unions have been perhaps understandably outraged. As I said, they've called it undemocratic, unworkable, and likely almost certainly illegal. So undemocratic, well, I guess the reason for that is that they've obviously, to get to the point of strike action, unions will have had to satisfy pretty onerous balloting requirements, and this bill would override the rights and wishes of the required statutory majority of workers in that situation. And just to recap, generally 50% of those entitled to vote in a strike ballot must have voted, and then there's a simple majority of those voting, which who must favour the action. But in particularly important public services, like the ones that we're talking about here, transport and health and education, etc., in these important public services, there's an additional requirement, which is that 40% of those entitled to vote must be in favour of the strike action as well. So it's pretty, as I said, it's pretty onerous. And if a union has gone to the trouble of putting in place the ballot and has managed to get the numbers, I suppose this, as I said, this drives a bit of a coach and horses through that, through the industrial action law there. So you can understand to a degree why the unions are up in arms about it. They say it's unworkable, and one of the reasons for that is there's nothing in the bill which talks about, which actually details what a minimum service level will look like. And I suppose, if I'm honest, there's a bit of a false advertising in the blurb for this webinar. In that, I think we said would tell you, what is a minimum service level. In actual fact, we can't do that. It's not possible because there's nothing in writing. There's nothing in the bill or even in the guidance to say what a minimum service level will look like. It's going to be down to what the Secretary of State ultimately wants it to look like, supposedly, as we say, in consultation with those that he or she deems appropriate. There is one sort of check on that, which is that the regulations that the Secretary of State must make or can make will be subject to approval of both houses. So one would expect it will be fairly heavily scrutinised, and to get the approval of both houses, I suspect there will need to be that consultation with the unions as well as with the employers. So the employers then must consult, and this is again why the union believes it's unworkable. When the employer issues the work notice, before they issue the work notice, they've got to consult with the unions. And again, my point is that if consultation was likely to be successful, then it probably would have achieved success before we're at this point of a strike being called. There is this point also, and this is something which the union are pretty upset about, which is that ultimately it's the employer's decision as to what the minimum service levels, or who is needed to satisfy the minimum service levels and what they must do. That's ultimately the employer's decision, and they say, well, that's kind of dictating rather than negotiating, and that goes against the sort of principles of the International Labour Organization, which says that in relation to strike action, guidance like this, rules like this, it should be negotiated rather than imposed. I mean, effectively, and this is the number of it really, unions are going to be obliged to take steps to ensure that their own painstakingly organised strike action is unsuccessful, or certainly is undermined. I mean, I've seen this described in some blogs as, unions are effectively being asked to collaborate with employers in order to ensure the ineffectiveness of their own strike action. And there is this kind of sense that are they almost like turkeys voting for Christmas here? If they do get quotes into bed with the employers to work out and thrash out what minimum service levels are they going to be seriously undermining their strike action to make it almost not worthwhile? And there is this, and that brings me back to this point which I mentioned earlier, that if a strike on its own merits is not particularly effective, then what else is open to the union other than to have more of them? Because only with more of them, lots of less effective strikes then becomes more effective potentially, and that has been picked up in some of the risk assessments for, the impact assessment for the transport strikes bill, which I'll come on to in a moment as well. Going on to the reaction to the unions, so yes, they regard it as undemocratic and unworkable, and I've said they're outraged, which I believe they are, to put it mildly. They're also indignant. They've said, or Paul Novak has said in his press release, this is almost certainly illegal, which is an interesting point given that the whole proposal is about putting in place legislation to enable what the government is proposing to become lawful. And obviously, if the law is passed, then what is proposed in theory shouldn't be illegal anymore. It's obviously illegal now to impose these minimum service levels because the bill hasn't become an act. And I guess what the TUC and unions are getting at here is that this, in their view, seriously undermines the right to strike. And we hear a lot about the right to strike in actual fact, there is no right to strike as such. What there is Article 11 of the European Convention on Human Rights, which says that everyone has the right to freedom of peaceful assembly and freedom of association with others, including the right to form and join trade unions for the protection of their interests. So it's not a right to strike as such, but case law around this article has reasonably firmly established that strike action is what's meant when it talks about protection of his or her interests. So although there's no sort of right to strike in legislation, the case law has effectively given workers and unions that right. But it's a qualified right. So the Article 11 goes on to say no restriction shall be placed on the exercise of these rights other than as are prescribed by law and are necessary in a democratic society in the interests of national security or public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. And he goes on to talk about how you can't restrict prohibition on striking police or the military. Now, again, there's been arguments for many generations around what this means, but a lot of it boils down to public safety again. And I think there's going to continue to be arguments as this goes through Parliament and after it's passed around, whether or not minimum service levels that are being proposed are really necessary in the interest of national security or public safety, for the prevention of disorder or crime, etc. So I think there's a very obvious playing field for dispute here, which is the European Convention on Human Rights and Human Rights Act in the UK, of course. I think unions are also indignant. Some of them feel that it's ironic that minimum service levels are being used to minimise strike action or strike action effectiveness, when for a lot of them, one of the reasons for strikes is the desire for better paying conditions to attract and retain staff to enable basic service levels to be maintained. So it does feel to them a little bit ironic that they have been calling for the tools and the resources to ensure minimum service levels. And now minimum service levels are going to be the stick to beat them with to try and minimise the effectiveness of strike action. There's also this point that I've mentioned about the government citing safety as a driver for the proposals, but in reality, how much safer will we be with minimum service levels in education, for example? As I said, I think you can get behind it in relation to nuclear reactor decommissioning, but I'm not sure, to be honest, how much industrial action there is in that sector. It's not something which has hit the news, but obviously in some of the sectors where there's been strikes, questions need to be asked, I think, about how much safer the public will be if these minimum service levels, however they may look, are introduced. So what does it all mean for you and your organisation? It might be that, if you're in one of these sectors, then clearly it's going to have a significant impact. But even if you're not working in one of those sectors, if your business operates, much more on the fringes of education or health or transport, logistics, etc., because of the wide discretion that the government is given, that the Secretary of State has, it's certainly possible that you and your business may be covered by minimum service levels legislation, because you might be considered a relevant service, even if you don't feel you're obviously in one of those sectors. If you are covered, then obviously in theory it would enable you to maintain a basic operation and presumably an income stream during those strikes. So that's something which will, I'm sure, be welcomed by employers in those services and sectors. You're also able to dismiss striking employees who are identified in the work notice. But I would say I don't expect that to be the end of the matter if you do. I would expect those employees to be to lodge claims, to be backed by unions, to be invoking the Human Rights Act, the European Convention on Human Rights, and that could obviously tie employers up in lengthy and costly dispute. I think, if I'm honest, I don't expect this to reach the statute book in its current form. I think it seems to me fairly clear that there will need to be some heavy scrutiny, and with 2024, I think, is likely to be the next general election. If that goes in favour of Labour, as I said, they've said they're going to repeal. So either way, I think what we have currently is something which is going to be debated and changed. I mean, one of the reasons is I think that it does appear to concentrate too much power in the hands of the Secretary of State, And I suspect the House of Lords, if not the Commons, will want to put a check and balance on that. They'll just want to see more detail rather than giving such wide discretion. I mean, I think the other point to make is, how much support does this bill actually have? It clearly follows through on what the Conservatives promised in their election manifesto, but it goes up an awful lot further. I mean, it's added, I think, an extra 6 sectors compared to transport, to which it was originally only supposed to apply. I've made the point, I'm not sure quite how effective strikes are these days, given that a large proportion of the working population can make arrangements. I did see, again, in the government's own risk assessment on transport, where they were looking at some of the strikes that had happened over the previous 6 months. I think only 13% of the working population surveyed said they'd been affected, and only 4% of that 13%, which is about 0.5% in total, actually said that they'd been unable to work. So on the government's own sort of impact assessment, some might argue that it's a bit of a sledgehammer to crack a nut, potentially. I think there is this point around, many people will say, we don't even have minimum service levels, even when there's no strike. There's many days when you can't get from A to B. I think there were days during certainly December where you couldn't get train or plane from one city to another in the UK. And if you tried to drive, I think the Highways Agency was on strike as well that day. So you'd expect pretty lengthy delays on the on the roads, and when you got there, the tubes and the buses were on strike as well. There were definitely 2 or 3 days where it was a full house almost of transport related striking. But as I say, there's this concern that generally, even when you're trying to get a train or you're trying to get an ambulance, there have been situations where people have waited days, literally days, for an ambulance, and where they've been unable to get a train because several trains in a row have been cancelled. So, and this is without strike action. So I think this point about what difference is it going to make if we have minimum service levels for strikes if we can't achieve basic service levels without a strike? I mentioned the transport strikes minimum service levels bill, which came out which was published in October last year, and which seems to have been pretty much superseded by the strikes minimum service levels bill, although the transport bill has not yet been removed. Going through the impact assessment there, it was very clear that there were some fairly significant risks and unintended consequences of the proposals, which were certainly, if not anticipated, then certainly acknowledged. And one of those was this lengthy and costly legal challenges, both by unions and by any dismissed employees. We can expect them to cite, as I said, the Human Rights Act, European Convention on Human Rights. Then there's also this point about non-compliance with the work notice, which, yes, an employer can dismiss, and they won't be found to have automatically unfairly dismissed, but that doesn't help them meet the minimum service levels, and it could make it, even more difficult to meet minimum service levels in future if, they're dismissing all those who work when identified in a works notice. Sorry, all those who strike when identified in a works notice. If there are minimum service levels introduced, then there's also this potential risk of increased action short of strike. So it's certainly highly probable, I would have thought, that if strike action is going to be undermined by minimum service levels, then unions may instead ballot for action short of a strike, so working to rule, or quiet quitting, as it seems to have been called over the last year or so, which was always basically working to rule. So if there's an increase in action short of a strike, that's not particularly what the government wants. But there's also, as I said, there's potential increased frequency of strikes as well. If a strike on its own is less effective, then, as I said, the unions may well look to have more regular strikes. So it would be ironic if this kind of supposed strike busting legislation ended up resulting in more strikes. So that was all the impact assessment, all in the impact assessment for the transport strikes bill. And maybe it's therefore not surprising that there hasn't as yet been any impact assessment for the strikes minimum service levels bill. And we wait to see whether or not they will come up with one. It seems a little bit late in the day now, or whether they, and if they do, whether or not they include those risks that and potential unintended consequences that were in the transport strikes bill. So that's I suppose a sort of half-hour run through what we expect, and why it's happening, what the different points of view have been, and my view, as I said, is that I think this is it's going to need some significant alteration before it becomes law, or at the very least, we're going to need to see more detail before it becomes law. So hopefully that was helpful. I'm just going to check and see whether we've got any Q&A, any questions here. If you do have any, then obviously pop them in there. We haven't got any at the moment, but obviously, I've got a couple of minutes now before we bring this to a close. As I said, we have recorded this, so we'll send this out as well. But if anybody has any questions, please pop them in the Q&A now. And if you want to ask it in person, then I can unmute you as well.
Can I ask a question, Angus?
Yeah, please go for it. Yeah.
Yeah, I was just looking. I was obviously I'm doing some research on this as you've been doing as well, and I was interested to see about what Grant Shapps's response to the unions, the criticism from the unions on this, and he seems to have made some sort of analogy with other European countries, and obviously we hear about strikes being always in France. It always seems to be the French are always striking. So I'd be interested to hear your views in terms of that, and whether you think was there any merit to what he was saying about it being in line with other European countries?
Yeah, I mean, I saw that, and I thought he was kind of over-egging the analogy a little bit, because he was in particular talking about France, maybe Italy and Spain as well. And whilst it's very clear that they do have minimum service levels provided for by legislation, the detail again is very scant. It's I was looking at what Italian and Spanish employment and French employment lawyers had to say about this, and they certainly seem to be saying in Italy and Spain, yes, we have these minimum service levels, but provided for, but actually the detail is not there, and therefore it still results in lots and lots of case law and lots and lots of uncertainty. So it's not the kind of the silver bullet that I think we were was being alluded to. I'm not saying we're having the wool pulled over our eyes exactly, but I do think it was I don't think the answer is immediately obvious in Spain, France, or Italy, and certainly anybody who's trying to go on some holiday to France would probably agree that they don't have this ironed out. And if those are the minimum service levels, then heaven help us, I think, given the situation we sometimes experience when trying to travel in France. So I can understand why he was trying to say, look, it's not just us, it's other similar countries in Europe who are doing this kind of thing. But yeah, I think I don't think it's a great point. I think just it's interesting because Grant Shapps, I think when he was Transport Secretary, he drew up a 16-point strike busting manifesto of sorts, and we're only at sort of 3 of these have been intimated so far. So I think we had the point around agency workers being able to replace striking workers, which previously was unlawful. Now that can happen. We also had the point about I think it was around fines being for unions being increased up to £1 million, which again was obviously a fairly serious and significant increase for the larger unions. So they can certainly lose out financially. Not that the larger unions can't afford it. Obviously, they're very wealthy organisations, but still, it will be a deterrent, I'm sure. And then this kind of minimum service levels is the 3rd out of I think 16 bullets, and the others I haven't got in front of me right now, but I know they will. They certainly would cause union leaders to turn white when they see what he has in store for them, and I don't think you'll get probably halfway through his list. But yeah, I think trying to justify it by comparing it to the situation in France, Italy, and Spain is probably not that helpful.
I agree.
Anybody else got any questions? And if not, we'll draw it to a close. No. On that basis, then thank you for joining us. As I say, we're going to send out the slides and we'll send out the recording. And we're interested in your feedback if it was helpful. If not, why not? And we look forward to seeing you on the next webinar, which actually is next week. We have one webinar next week on employment taxes, which is going to be presented by my colleague David Chandler. So it's going to be well worth tuning in for that this same time next week. With an update on where we are related to things like IR35, etc., etc. So please do join us for that one. A week after that, we have the third in our series, which will be in relation to global tech visas, global immigration, basically. And my colleague Chris Dias will be presenting that one in a fortnight's time. So please do join us for that as well. But otherwise, thank you for joining us today, and we'll see you on the next one. Thanks a lot.